Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, everyone. Welcome to another edition of the Empowering Plans Podcast. I'm your host for today, Brady Bizzarro, and joining me is our own attorney, Andrew Silverio. Say hello, Andrew.
Hello.
Awesome. Following instructions so far. Well, today we've got an interesting topic we want to talk about. Very timely, much in the news, specialty drugs. But we're going to focus on a niche area of this topic that has to do with patient assistance programs. So most of you listening today probably know something about these programs. Maybe you don't, though. And so we're going to talk about sort of what they are, the background, how they came to be, what the latest sort of policy issues have been with patient assistance programs. And then we'll talk about a very important case that really could be changing the game with how these programs are actually administered, or certainly could outline some risks for plan sponsors and how they interact with them. And then Andrew will talk about that. But it's definitely timely because we just had this giant piece of legislation passed called the Inflation Reduction Act. It had a lot of provisions in it having to do with drug price negotiations, right? And patient assistance programs are effectively, or were supposed to be, an attempt to try and bring down the price, right, of drugs for patients. That's ultimately their goal. And what we've seen over time is they've really gotten convoluted. There's been different players in the industry trying to position themselves in ways to take advantage of these programs to the exclusion of other parties involved. And so how do we get here? Why is this happening? I think it's helpful to start off by thinking about why these programs exist, right? So if you think about the number of drugs, there are about 300 drugs that are associated with patient assistance programs. And these are basically the attempts by the manufacturer to offer financial support because these drugs are typically very, very expensive. Typically, the programs themselves come in two different forms. Either there's a copay card, like a discount card that the patient can present upon sale of the drug, or when they're at the pharmacy and they can get their copay entirely covered in some cases or partially reduced. That's one way. The other way is there are actually these independent nonprofit charities that manufacturers themselves actually help fund. And these charities can also cover the costs of these drugs for patients as well. And so patients can apply to them based on certain income guidelines. Really over time, though, what the trend has been and what policy analysts have noticed is that these programs aren't always so great at lowering costs. Sometimes they actually drive costs up, and some of the incentives there are in the wrong place. I mentioned these independent charities, and it's interesting to note that the federal government has brought a number of lawsuits against manufacturers, arguing that they have a conflict of interest in cases where they are both funding an independent charity and then raising the price of their specialty drug. And then basically, the charity will buy the drug outright, very, very expensive. And you can see there's some conflict of interest there. But the more common one that we see in our industry has to do with the drug coupons. And over time, there's been a debate back and forth about whether or not plans should be allowed or are allowed to count the value of manufacturer assistance coupons to a patient's out-of-pocket maximum. I'll spare you the details because we want to talk more about this case on today's podcast. But basically where we're at today is the Biden administration is being sued by a number of patient advocacy groups over a rule that passed under the Trump administration, which basically gave the plan sponsors the option of whether or not to include in the cost-sharing amount the value of the manufacturer's coupon. The administration today is not enforcing that rule. And so most plan sponsors are not counting the value of a drug coupon toward a patient's out-of-pocket maximum. And as a result, these patient advocacy groups argue that patients are paying a lot more because they're not hitting their out-of-pocket max as intended by the coupon, some would argue. And so insurers are getting money from both the patient and the manufacturer from the value provided to them from these coupons. So we'll see how that lawsuit plays out. But for now, copay accumulator programs exist. They continue to be administered across the industry, and yet we're still seeing prices come up. But throwing a wrench into that discussion, there has been a few recent developments, most recently in the form of a lawsuit involving Johnson & Johnson that could call into question some of the practices that plan sponsors have been engaging in to get access to these programs on behalf of their members. And so, Andrew, I'm hoping maybe you can talk about this particular case in general, the background, why it came up, and what it means for the industry.
Sure, and thanks for that background. The case we're talking about here, Johnson & Johnson, of course, the large drug manufacturer, have taken aim at a vendor administering one of these manufacturer assistance programs called Save on SP. There's two main elements here that they're challenging, and they're not really unique to this program. These are both elements that we've seen in other programs that a lot of folks out there are doing. The two main things here that Johnson & Johnson objects to are, one, like Brady mentioned, the classification of certain specialty drugs as being non-essential. The reason for that, of course, is that if something is an essential health benefit, the cost sharing has to be counted towards out-of-pocket maximums. You can't apply dollar limit maximums, that sort of thing. Basically have a lot more leeway in structuring plan benefits and cost sharing if something isn't an essential health benefit. So with a drug that may have a manufacturer assistance program available, if it was not an essential health benefit, you could essentially raise the cost sharing on that drug as high as you want, and you would never have to worry about hitting an out-of-pocket maximum. And the potential savings, if you could extract it from that manufacturer assistance program, would essentially be limitless. The only limit would be the amount available under the manufacturer assistance program itself, as opposed to just hitting that out-of-pocket maximum, at which point the plan would have to pay the benefit at 100%, essentially. So Johnson & Johnson is alleging that doing this violates the ACA. Basically, prescription drugs are an essential health benefit and specialty drugs are prescription drugs. So there's really no justification for this. The other element that Johnson & Johnson is objecting to here is the kind of manipulation of the cost sharing under the plan based on whether assistance is available and how much assistance is available. So we've seen terminology like floating copay, variable copay, where instead of a static figure where your copayment for specialty drugs, maybe it's $200 or $100 from a formulary and $200-300 outside of the formulary. This will actually be a variable copay where it will increase based on how much assistance is potentially available. So by doing this, Johnson & Johnson is alleging that the plans that this program operates with are extracting a lot more money than they normally would be eligible for out of these programs, something from maybe the $1,500 range per patient up into $4,000, $4,500 range for someone who's enrolled in one of these programs. So overall, they're claiming that this vendor and the plans that they serve have extracted $100 million from their copay assistance program, which they're not properly eligible for. So that's a big number. Why this program, if there are so many others out there doing the same thing or similar things? That's a great question. We were asked yesterday by a client, and there are any number of strategic reasons Johnson & Johnson may have chosen this program to take aim at. We really would just have to speculate at this point. But really, the holding could be much more important to not just Johnson & Johnson, but to manufacturers as a whole than any specific ruling that they might get as, in relation to any particular program. The $100 million is a big number, but if they could strike a blow to these programs as a whole, that holding could be a lot more valuable, actually, even than a $100 million ruling.
Interesting. One of the things I think about when I consider this case and sort of how it came about is, this is the result of plans looking for creative ways to try and control costs, right? The reason that they're either partnering with vendors or adopting language, right, that is now drawing the attention of manufacturers is because, these patient assistance programs can be pretty valuable. The drugs are very, very expensive, right? The assistance available can go pretty high. I think some, as high as close to $1,000, per dose or per month, depending on how the drug is dispensed, right? And it's difficult for plans. I mean, from their perspective, before these rules came out and this discussion about counting the value of copay cards towards out-of-pocket maximums, from the perspective of a plan, if you were counting the value of a discount copay card, right, toward a patient's out-of-pocket maximum, then they're going to hit that out-of-pocket maximum pretty quickly. And from the perspective of the plan sponsor, the patient hasn't really paid all that much because the coupon eats up a huge portion of the out-of-pocket. And so it was creating an incentive for patients to pick a specialty drug, even in cases where you had a generic drug available, right? Because the copay that ultimately, or coinsurance even, that's paid by the member is much, much lower because of these programs. And so a lot of these new attempts and creative attempts by plan sponsors and vendors to adapt have been in response to that problem, right? To try and make sure that patients have skin in the game, that they are selecting generics where it's appropriate. And I think it's going to be hard. I don't know what you think about this, Andrew, but there's probably a balance to be struck. It seems like things could go too far the other way, right? And that's why you have this lawsuit now being brought by certain patient advocacy groups against the administration, because they're saying, look, administration, you're not following the rules here. You're not enforcing the rule, and you're allowing now any drug discount card to not be counted for the out-of-pocket max. And that's too burdensome in their view against a patient. So it's kind of going back and forth with the incentives all over the place.
Yeah, it's definitely a swing the opposite direction. And I mean, from the perspective of these programs, if payers are allowed to basically take all of the benefit of these programs that's supposed to be for plan participants to ease their out-of-pocket impact, that sort of defeats the whole purpose of these programs. Of course, on the other side, as we know, and Brady kind of alluded to, a lot of the reason these programs are even in place is to incentivize the use of these higher cost drugs in the first place. So are there situations where a new expensive drug might be the only treatment available for a particular condition, and somebody not being able to afford it, it could be a death sentence? Sure, that situation exists, but a lot more often it's really that there are lower cost drugs available. And by canceling out somebody's out-of-pocket responsibility with a copay card, a manufacturer can incentivize them to use that higher cost drug with brand name recognition, because let's face it, patients more often than not don't care about anything other than their out-of-pocket. They would rather get a $100,000 drug with a $0 copay than a $2,000 drug with a $100 copay. That's really what they see as the out-of-pocket hit. So there's legitimate arguments on both sides, but, definitely the argument could be made that allowing free reign either way is just gonna tip the scales too much.
Yeah, one last thing before we talk about maybe what plan sponsors should do in the future is, if you consider how these programs work with Medicare, you'll see that they don't. They're not allowed to be used for Medicare enrollees. There's tons of cases, including recent ones, involving manufacturers that have tried to sue the federal government because a federal law called the False Claims Act and also the anti-kickback statute make it pretty much impossible for manufacturers to use patient assistance programs for Medicare enrollees, because those laws are meant to protect, what Medicare spends, and frankly, any federal government program. But in the view of the federal government, these programs act as basically a kickback to manufacturers by basically incentivizing patients to pick, as Andrew pointed out, a more expensive drug when there's not, when there's another version available. And so you'll see that manufacturers are always trying to get that rule sort of undercut, because for them it would be huge if they could issue these programs or utilize these programs for Medicare enrollees. You're talking, probably hundreds of millions of dollars that they're not making in revenue. So we'll have to see how those lawsuits play out. But for now, these programs exist in the private insurance market, and we expect that it'll stay that way for the foreseeable future. But if you are a plan sponsor, Andrew, what are we recommending to clients in light of this lawsuit to protect themselves? I guess without giving away the store, right? From a high level, what should plans be doing?
Sure. Well, these programs vary just as much as the manufacturer programs that they kind of take aim at vary. But there's some general concepts that we like to propose. So we want to be on the lookout for any sort of element of deception. We want to protect the plans we work with and be risk averse as far as that sort of approach. So, if we have a situation where we're representing to a manufacturer that there's no coverage for a drug when that's not true, we're not big fans of that. There's also been a mechanism that's gotten a lot of popularity in recent months called a MERP. You've all probably heard that acronym being tossed around, Medical Expense Reimbursement Plan. The issue with the MERP is really that a MERP isn't any sort of specific structure. It's a categorical term. So every health plan is a MERP. Your full-scale medical plan that you buy stop loss for is a MERP. So if you're setting up a separate MERP to cover a drug, if a patient can't get assistance from a manufacturer, you should be asking what that MERP actually is. Is it an HRA? Is it a separate group health plan? And then you can start to figure out what potential compliance issues might arise, because just calling something a MERP doesn't really tell you anything about what it is, how it's structured, what rules apply to it.
Absolutely. Well, definitely stay tuned to our webinars, our podcasts in the coming weeks and months, because this issue is definitely not going away. This lawsuit is not going away. There'll probably more like it that come out. And I expect also this one I'm following here against the administration for not enforcing the Trump era rule on copay accumulators. That's one to follow as well, because ultimately, no matter what is decided by the administration, they're going to annoy one group here, either the manufacturers, the PBMs, or perhaps even patients. So there's no clear-cut answer right now for how to handle the problems that are caused by patient assistance programs. I think in spirit, to Andrew's point earlier, they do make sense in certain cases, but you definitely have to make sure that you're aware of the latest developments on what is allowed and what the best practice is. And for that, make sure you're following all of our media and certainly asking us questions if you have them as well. But for now, on behalf of myself, Andrew Silverio, and our producer, Pat the Man Santos, I want to thank you all for listening again to another edition of the Empowering Plans podcast, and we'll talk soon.